deem that person to be in effect the owner of that money. We'll acknowledge that these are meaningful parameters, and yet at the same time they're relatively broad. So let's go back to the role of that trustee again. Now you can see you've got to have a trustee that whose judgment you trust, but I'll tell you that there are fairly well settled parameters when you interpret those terms, and that's one reason they're very attractive, is that they have developed a sort of standardized usage in the industry. So it's not as if this is entirely squishy and entirely vulnerable to interpretation. It's not. There are reasonably concrete limitations on those terms. They're very popular with people who are doing estate planning because they allow emergencies to be met, they allow some flexibility to address needs, but you give the authority at the end of the day to your trustee to make those decisions. And that allows your surviving spouse to have access to funds, but yet an opportunity to pull back the reins when you see some of those clouds on the horizon or some of those suspicious circumstances that you envisioned. So you want to create, though, this bypass trust to have these standards that will govern the payout. But what about the money at your spouse's death? And that's another reason you want those standards. You want standards to assure that at the end of the day the money will go to your children, even your grandchildren, depending on who you're primarily concerned about down the road, where you'll release the funds from the trust. Now we have what's permitted in most states, what's called a dynasty trust. So technically now, as opposed to years ago, you can have a trust stay in effect for multiple generations, almost indefinitely, under many states' laws. A dynasty trust now is a trust that can live on for 5, 6, 7, 10 generations potentially. There's a concept called the rule against perpetuities that for a long time limited how long you could have a trust in effect. And it was a public policy concern that they wanted assets to not be tied up in families. They wanted them to be freed up for the economy, etc. But in recent years that has lost its persuasiveness, and after a life of hundreds of years, these limitations related to perpetuities have now been relieved or released in certain jurisdictions, and there's the opportunity to have these dynasty trusts. Most clients are not concerned about a trust that survives that period of time. Those of you who have substantial assets, though, this piece of information may be helpful to you. But many will be concerned as far down as their grandchildren, and that may trigger, incidentally, a whole new issue when we're talking about estate planning. When you go to your estate planner and you start talking about benefits 2 generations down, they're going to talk about the generation skipping tax. I'm not going to cover in this show the details of the generation skipping tax, but I just want you to be familiar with that phrase and be aware that when you do start giving gifts 2 generations down, that you may trigger an additional tax. But most people, when they're doing their bypass trust, they're thinking about providing income of some sort with some limits to their surviving spouse, and then thereafter distributing it to their children, or maybe having it continue for a period of time in their children's lives. That's probably another show when we will talk about when is the best time to free up funds, when somebody reaches the age of majority, at age 35, or never completely released, but all in the form of income or specific distributions. So when you're planning your AB trust, you have to think about, number one, how much you're going to make available to the surviving spouse. You can use the HIM standard I just mentioned. You can use income. I mean, while it doesn't give as much flexibility, it's not at all uncommon where your primary consideration is not your surviving spouse, but rather to your children or your grandchildren. In that case, maybe you do limit it simply to income. In some cases, I've seen it where the surviving spouse gets none, where there's enough money that's being transferred to the marital deduction trust that the client feels that there's plenty there, and there's no need to make any of these funds that go into the bypass trust ever available to the surviving spouse. And that's okay too. This will be driven entirely, of course, by your circumstances, but I want you to get kind of the underlying considerations here and to think about those when you're doing your bypass trust. Now let's shift over and talk about that other trust, the marital deduction trust. Let me first add that these marital deduction funds, they don't have to go in a trust. Commentators have written a great deal about the fact that marital deduction trusts are really only relevant when you're thinking about management issues. Remember we talked earlier about when you do estate planning and you get down to the most fundamental considerations, they generally are going to fall in one of 2 categories: tax considerations or asset management situations. And these sometimes overlap, but the bottom line is that usually you're concerned about one or the other primarily. And when we talk about a marital deduction trust, we have to be talking primarily about asset management, because there really is no tax advantage to creating this trust. You get the tax benefits of the funds being utilized as a marital deduction. So that marital deduction we know is unlimited, and once that's acknowledged by the IRS, which it will be if you give your assets to your spouse, then you're going to avoid that taxation. So you don't need a trust to avoid it. When you start talking about a marital deduction trust, in other words, not just a trust here with your bypass, but a marital deduction trust, generally you're thinking about concerns about how the money is going to be managed and trying to place limitations on that. Let's take a step back and look at the marital deduction concept. The IRS has essentially said, look, we will postpone the taxation until the death of the second party, but we want to be assured that the money will come out of that estate and that there will be taxation then. So there are a number of rules that regulate this unlimited marital deduction, as you would expect. And you would expect those rules to attempt to avoid having those funds disappear along the way between the time that they're in your estate up here and they're transferred over to your wife's name, and then down the road here she dies at this point. Well, what these regulations and these very specific rules are from the IRS is that they're concentrated on this period of time. They don't want there to be any device by which you might sidetrack these funds and have them not ultimately make it to this point where they're intended to be taxed. The IRS's perspective is that we've been very generous here. We've postponed this tax for what it could end up being decades, but we want to be sure that at the second spouse's death that we can tax what's left. And it may be larger than in fact she inherited, depending upon how the funds was used, how it grew, how it appreciated, etc. So the question becomes, what devices are viewed with suspicion or disapproval by the IRS? Anything that can end that estate, and there are really two general things that might do that. One would be a terminating interest. It's called a terminal interest rule. The terminal interest rule simply says that any time that an asset ceases to be in the name of the person who received it, in this case the surviving spouse, that's going to violate the terminal interest rule, and as a result it would not qualify for the marital deduction. And they'll look at this at the moment of your death. So when those funds are being considered to avoid taxation at your death because of the unlimited marital deduction, the IRS is going to want to scrutinize what the title says, whatever the title documents are, whatever the will is, whatever is determining what the surviving spouse receives. The IRS is going to want to scrutinize that. And if they see things such as a life estate or a condition or a contingency whereby at some point, say your wife at age 40, the asset reverts to a child, or at your wife's death, the asset goes to a child or a nephew. Anything that shifts the ownership would effectively take that asset out of the wife's estate. And that makes sense, doesn't it? I mean, the way the rules are governing a taxable estate, if you have a life estate in something, and at your death it shifts to someone else, as it typically will. It'll either revert to the person that gave you the life estate, the right to use the farm for the balance of your life, for example, or it'll go to another person, perhaps your brother. This was more common in families years ago than it was today. But the way that the gross estate rules work for purposes of taxation is that wouldn't appear in your estate because it never got to your estate. The moment you died, you ceased to have any interest in that real estate. So life estates are a good example of a terminable interest. It's an interest that at your death dissipates. So if you gave your wife a life estate and your assets, and then thereafter it was to go to someone else, that would fail for the marital deduction, and it would be taxed in your estate. And another would be a contingency. If my wife marries, if she remarries, these assets shall belong to my brother. That is an example where the IRS will look at those terms at the moment of your death, after your death, and ask, is there a terminable interest here? And if there is, then they'll say this doesn't qualify for the marital deduction. And that makes sense, doesn't it? It doesn't make it to the point where it's to be taxed. So all of those conditions have to be absent for you to get this money to qualify for the marital deduction. Now, having said all that, the IRS has carved out an exception. There is an exception called a Q-tip. Now, I know this seems esoteric to you now, but just listen to these concepts, and it's only important that you get a vague idea of what's going on here for you to be much better equipped when you go and meet with your estate planning attorney. So bear with me here. He's going to use the phrase, I assure you, of Q-tip. It's a quality